How many times would you say you
4 to 5. I saw him stumble and fall to the ground.
A child have had access to a firearm, and it ended up with him shooting someone.
You are never able to beat, rape, traffic, isolate, choke another woman ever again.
In August 2020, Walter Hart Jr. attended his nephew's funeral at West Haven Funeral Home in Jackson, Mississippi. During the service, tensions arose over a mistake in the obituary, leading to a heated argument between Hart and Amini Olugbala's stepmother. As Hart was leaving and seated inside a vehicle, Olugbala approached and fired a shot through the closed window, fatally striking him. Surveillance footage later confirmed that Hart had not returned fire, and evidence recovered included both the weapon used and Olugbala's police interview, in which he claimed he acted out of fear. Following the investigation, Olugbala was charged with murder and shooting into an occupied vehicle. During the trial, the jury reviewed video evidence and heard testimonies from both sides. After hours of deliberation, they found Olugbala guilty on both counts.
You had to watch them bleed out and die in front of you. It's a lot. People would never understand it. So it feels so good to know that it just feels good. And I'm glad the jury was able to see the facts.
Olugbala's sentencing was scheduled for July 9th, 2025, where he faces life imprisonment for murder alongside additional prison time for shooting into the vehicle. 2 other individuals also face charges connected to the case as legal proceedings continue. In April 2021, 29-year-old Taylor Pomaski vanished after attending a party at her home in Spring, Texas, where witnesses reported seeing her abused by her boyfriend, former NFL player Kevin Ware Jr. She was reported missing 2 days later, and months passed without answers. In December 2021, searchers discovered human remains in a Harris County ditch, which were later confirmed in April 2022 to belong to Pomaski. As investigators dug deeper, they uncovered disturbing details. By July 2022, Ware was indicted for murder and tampering with evidence. This came after he had already been arrested in 2021 for unrelated weapons and drug charges, leading to a separate 15-year sentence. In May 2025, to avoid a potential life sentence, Ware pleaded guilty to both the murder and tampering charges.
Taylor's death made sure you are never able to beat, rape, traffic, deny food, isolate, or verbally abuse another woman ever again. The violence and abuse prior to her death match her violent death and the way you treated her body. You're a sick man. You're not special. And while we are satisfied that you will be old and lonely man in 30 years, this will never bring Taylor back. You, Kevin Ware, have inflicted immeasurable pain on this family.
He's not going to hurt anybody anymore. He's going to be gone for a good while, so Harris County citizens can, rest easy a little bit.
During sentencing, Pomaski's family described the pain of her loss and the abuse she suffered, expressing relief that Ware would never again have the chance to harm another woman, even though nothing could bring Taylor back. Ware was sentenced to 30 years in prison to run concurrently with his earlier sentence. In July 2024, Sonya Massey called 911 to report a prowler near her Springfield, Illinois home. Sangamon County Deputy Sean Grayson responded to the call.
Oh, it hurt you. You called us.
He then entered her kitchen, where Massey stood near a pot of boiling water. Moments later, Grayson ordered her to drop the pot, then fired his weapon, striking Massey and killing her. The investigation revealed that Massey was unarmed and posed no threat. Grayson was quickly terminated and indicted by a grand jury on multiple charges, including first-degree murder, aggravated battery, and official misconduct.
This guy should have never been given a badge and a gun anyway. It would be fine with me for him to breathe free air when my daughter gets up and walks out of that cemetery.
The incident brought attention to Grayson's previous disciplinary issues at other law enforcement agencies that had not been disclosed during his hiring. This involved a high-speed chase that he refused to discontinue and ended up hitting a deer.
We're at the end of 2nd Street. She's taking a right.
Following the shooting, Massey's family secured a $10 million civil settlement from Sangamon County, which also included commitments to improve police training and accountability.
It's just sad that we had to have had a tragedy like this with the Sonya Massey murder to realize that we're doing things wrong. This is an opportunity to have some checks and some balances and some processes to make sure that we don't find ourselves in the same position and situation that we did when Sean Grayson was hired.
Illinois can be the leader in the whole United States in this common sense legislation. I think that my daughter's life, it won't be in vain.
As Grayson awaited trial, his attorneys sought his release, citing his colon cancer diagnosis, while prosecutors emphasized the seriousness of the charges and his failure to provide aid after the shooting.
This is someone who acts impulsively.
The Illinois Supreme Court heard arguments on his pretrial detention in May 2025, but had not yet issued a decision. Due to widespread publicity, the trial was relocated to Peoria County and scheduled to begin in October 2025. In December 2023, Auden Torres accidentally shot and killed his longtime friend, 18-year-old Jacob Ferrell, while handling a firearm at an Apopka mobile home park. The bullet struck Jacob, leading to his death. Prosecutors later described the incident as a tragic accident involving a minor who should never have had access to a weapon.
And this was an accident. The evidence in this case shows us that this was an accident. This was a child that should never have had access to a firearm, that was playing with that firearm, and it ended up with him shooting someone.
Authorities charged Torres as an adult with manslaughter and possession of a firearm by a minor. The investigation also focused on how Torres was able to obtain the weapon, raising concerns about youth access to firearms and weapon safety. In May 2025, Torres pleaded guilty as part of a plea deal.
It should have never happened. And if this was such an accident, then why didn't he point the gun down at the ground? Why did he have to point it at Jacob, period? Why did he even have the gun outside? I can't talk no more.
There's always an empty seat at a holiday or a birthday. I never get to see my son get married. I never get to see him have children. I never get to see him raise a family.
Doesn't give him a right to take a gun no matter what and point it at anybody. Even my 8-year-old granddaughter knows you don't point a gun at nobody. And I don't even understand why he even had a gun.
During the sentencing, Torres broke down in court and apologized to Jacob's parents for the pain he had caused.
I want to apologize to Jake's parents, Missy and Mike, for all the pain and sorrow that I've caused. I know that the pain will never go away, but I hope it will lessen over time.
Despite his apology, Jacob's family expressed deep frustration, feeling that the sentence was too lenient for the loss of their son.
I will sentence the defendant to 5 years in the Department of Corrections.
He was sentenced to 5 years in prison, followed by 2 years of probation. Jacob's loved ones continue to honor his memory, many wearing tattoos in his name and keeping his ashes close as a reminder of the young life that was tragically cut short. In November 2024, tragedy struck in Westland, Michigan, when Robbie Gravel accidentally shot himself after gaining access to an unsecured firearm inside his home. Despite efforts to save him, Robbie passed away later that evening, leaving his family devastated.
Loved his laugh. It would make you belly laugh, and he couldn't stop.
His parents, Timothy Gravel and Heather LeBlanc, were charged under Michigan's safe storage law, which requires weapon owners to secure their firearms and prevent access by minors. Both were arrested and released on bond while awaiting trial. Eventually, they reached a plea deal that led to their sentencing in May 2025.
This was negligence. It really was. And sir, I know that you know that. And this is something that you're going to have to live with for the rest of your life, the loss of your child.
During sentencing, the judge acknowledged the lifelong burden they would carry due to their negligence. Robbie's grandparents, while heartbroken, expressed disappointment with the sentence, feeling it was not enough compared to the permanent loss of their grandson.
This is not justice. Robbie is gone forever. Yet the defendants will soon return to their lives, free to move on, while we are left to carry this loss for the rest of our lives.
We had to leave the anger at the courthouse today. We don't want this to happen to another child.
Choosing to channel their grief into advocacy, they urged others to practice responsible weapons storage.
Especially with safe storage for firearms. We totally agree with people owning, but they have to be smart about it, especially when there's children involved.
You have to have common sense. Put it away. Lock it up. Be smart.
You don't want what happened to us to happen to your family.
Love your kids, love your grandkids, hold them tight. You just never know.
Their message was simple: lock up firearms, value every moment with loved ones, and never take safety for granted. The court sentenced both parents to 5 years of probation, with the first year to be served in Wayne County Jail. In November 2024, Lincoln Park police officers attempted to arrest Darryl Jackson for a parole violation. When officers approached him on Outer Drive, Jackson fled on foot toward a nearby creek.
He entered the creek. I decided not to enter directly behind him.
During the chase, he pulled out a weapon and fired at Detective Jason Lisinskis. The shot caused severe injuries, leaving him in excruciating pain.
I immediately felt the most horrible sensation in my life. It was like being electrocuted, massive pain in my leg. It was the worst moment of my life, and I don't know if it would be considered tunnel vision, but I wasn't exactly aware of anything else other than him at that particular time.
Despite his injury, other undercover officers continued the pursuit. Jackson, still armed, pointed the weapon again at another officer, prompting them to fire back in self-defense. The returning shots caused Jackson to stumble and fall, after which he tossed the weapon aside and surrendered.
He put the pistol underneath his left arm and pointed it directly at me.
What do you then do?
I fired my pistol at him in self-defense.
How many times would you say you fired?
4 to 5.
Okay. And do you know whether or not those shots took effect?
I believe that they did because I saw him stumble and fall to the ground.
Following his arrest, Jackson faced 21 charges, including assault with intent to murder. During a preliminary hearing, detectives testified about the confrontation, describing Jackson's actions as a direct threat to their lives.
But by the grace of God, Mr. Jackson did not have a good shot, is the only reason it appears as though the sergeant was not killed.
Judge Elizabeth Danto found enough evidence to move the case forward, noting that it was only due to Jackson's poor aim that the detective survived the attack. With the charges bound over for trial, Jackson's next court appearance was scheduled as the legal process continued to address the dangerous events of that day. In February 2015, Erika Sandoval entered the home of her ex-husband, Exeter police officer Daniel Green, and fatally shot him while he was in the bathroom. Sandoval later admitted to the killing, but claimed she acted out of fear due to alleged abuse. Prosecutors, however, argued that jealousy over Green's new relationship drove her actions, pointing to evidence such as a sticky note with the name of Green's new girlfriend found in Sandoval's belongings. Her first trial in 2019 ended in a mistrial when one juror refused to convict, leaving the case unresolved for years. A decade after the murder, Sandoval faced a second trial beginning in early 2025. The jury deliberated for several days before finding her guilty of first-degree murder and firearm use.
Obviously, there's some disappointment, but for the most part, we're very happy with the verdict that the jury reached, particularly because we've always known that this wasn't a death penalty case. We have sought tirelessly to make sure that that part was told, and I think that that was heard loud and clear today.
I think they've had 10 long years, and this is a level of closure for them.
I feel relieved for the family. I just needed to be here for closure. It was a hard case to be on.
In June 2025, she was sentenced to 50 years to life in prison, 25 years for the murder, and an additional 25 years for the firearm enhancement. Having already served 10 years, Sandoval may become eligible for parole after serving 20 years and reaching the age of 50. Both families expressed mixed emotions after the verdict, with many acknowledging that while justice was served, the pain of the loss remains. Nathaniel Radimak, first known for a series of violent road rage incidents in California, became widely recognized as the Tesla road rage driver. In Los Angeles, he attacked several motorists, smashing windows and threatening drivers while behind the wheel of a Tesla Model X. After being convicted on multiple charges, including assault and vandalism, he was sentenced to 5 years, but was released on parole after just 10 months. Following his release, Radimak relocated to Hawaii, where his aggressive behavior soon resurfaced. On Good Friday, while at Planet Fitness in Kahala, Oahu, he confronted a woman, aggressively warning her not to walk past his exercise machine.
Walk up again.
Say that again. I walked past the machine he was using, and he came up behind me and said, "Hey, do me a favor, don't walk past my machine when I'm using it again." And I was so taken aback because I'm not one to be spoken to like that. So I just said, "Don't talk to me like that." And then he said, "You want to try me, bitch? I'll sock you right in your face."
When she stood up to him, he threatened to attack her, narrowly missing. The woman managed to capture part of the encounter on video and later identified him by matching his face to news reports of his California crimes.
What is your problem?
I'm telling you right now, things ain't looking good. Why are you recording?
Get away from me.
What's going on? What are you doing? Stop recording me.
How close was he to actually hitting you?
It was a hair. It was a hair away. It happened so quick. I saw him getting close to me, so I was automatically like, I guess in defense mode.
Only weeks later, on May 7th, Radimak was involved in another violent incident in Kaka'ako, where he attacked a mother and her daughter during a road rage confrontation. After nearly hitting their car, he turned around, exited his vehicle, and struck both women.
I heard somebody say slow down or hey, I couldn't really hear it, but that's what it sounded like. And then a few seconds later, I saw the car make a U-turn and come back. And then I saw the guy go across the street and reach into the car and looked like it punched her.
He was arrested the next day and charged with unauthorized entry into a motor vehicle and multiple counts of assault. As legal proceedings moved forward, Radimak pleaded not guilty while remaining in custody with bail set at $100,000. While incarcerated, he was attacked by fellow inmates, sustaining injuries that briefly delayed his hearings. With possible parole violations under review, authorities also consider extraditing him back to California, as his violent pattern continues to raise serious public safety concerns. Edward Jagst, a 21-year veteran of the Canton Police Department, was deeply respected in his community for his kindness, humor, and dedication. He served for years as a school resource officer at Plymouth Canton Educational Park, becoming a trusted and friendly face for countless students and staff.
He still had so much more time to live. He had so much more life ahead of him.
His gentle nature extended beyond high school, as he spent a decade teaching safety lessons to younger boys and girls, always patient with their endless questions.
Always open to answering questions, and you can imagine elementary age kids have some doozies sometimes, but he was always welcoming of those questions and answered those in a very kind and understanding way.
Former students described him as embodying everything a good police officer should be.
He was one of those people that just really embodied what a police officer should be, in my opinion, especially with all that's been going on with public opinion of the police. He was one of the good ones. You almost expect to hear of officers being killed in the line of duty, but to hear of it happening in their own home by a family member is just a whole new level of shock.
Outside his professional life, he was known as a devoted family man, actively involved with his family and strongly connected to his faith and community.
He definitely always seemed to me as a family man, and it seemed like he got along pretty well with his family from what he told me, so it definitely made it a lot more shocking. He was very kind, very gentle, and very supportive of our community, and he'll definitely be missed.
The community was devastated when news broke that Jagst had been fatally shot inside his Brighton home. Police responded after his daughter called 911, reporting that her brother, Hayden Jagst, had shot their father and fled. Hayden, 18 years old at the time, was located shortly after and peacefully surrendered to authorities. A weapon was recovered from his vehicle. While a motive was not disclosed, it was revealed that Hayden had a previous conviction and was on probation for possession of burglary tools. He was charged with open murder and held without bond. On March 13, 2024, Brenley Lawrence was found unresponsive by his mother, Jordan Elizabeth Shank, inside their Pierce County, Washington home. The boy was discovered next to vomit and not breathing. Investigators later confirmed that Brenley died from acute fentanyl toxicity. Court records revealed that Shank, who admitted to using fentanyl twice daily, even while pregnant, had taken the drug the day before her son's death. The home was found in severe neglect.
I would like Brentley's to not go in vain. I would like the state to make the changes they need to make to protect these children, because as of now, Brentley's just another tally mark, and that is horrific.
Family members, including Brenley's aunt, Kelsey Osborne, disclosed that multiple reports had been made to Child Protective Services and medical professionals long before the tragedy, but no action was taken to protect the boy.
This is a nightmare. The state failed him as far as I'm concerned. There were multiple CPS calls made. His pediatrician called, I called, the neighbors called, family members called, and to no avail.
Brenley's grandmother, Bonnie Johnson, expressed her heartbreak, struggling with both grief and anger, while acknowledging her daughter's struggles with addiction.
At the time of the child's the home he was living in had no running water and was in complete disrepair. There appeared to be human excrement in all of the toilets that were unable to be flushed, and dog feces throughout the house.
It's probably the worst thing that has ever happened to me. I don't hate my daughter. I love her. Am I angry? Yes, I'm angry my grandson is gone. But do you know anyone that's on drugs that has morals or makes right decisions? No, they don't.
Following the investigation, Shank was arrested and charged with first-degree manslaughter. She pleaded not guilty during her court appearance, and her bail was set at $750,000. In the early morning hours of May 11, 2025, Las Vegas Corrections Officer Maurice Washington was driving north on Decatur Boulevard when he struck 58-year-old Elijah Givens, who was walking across a marked crosswalk but against the pedestrian signal. After the collision, Washington continued driving for about half a mile until his vehicle broke down. Instead of calling the police, he contacted his mother and returned to the crash scene with her approximately 45 minutes later. When officers arrived, they noted clear signs of impairment and later admitted to drinking earlier that night at a hookah lounge. He failed field sobriety tests and was taken into custody.
Drives about a half a mile away from the scene and then finally stops. Not because he had a change of heart, but because his car became inoperable. He did make a phone call, not to law enforcement, but to family members. 46 minutes after the collision, he did come back to the scene. And at that time, when police made contact with him, he had a strong odor of alcohol emitting from his breath. He had slurred speech. He had problems pronouncing words.
Washington was charged with multiple offenses, including DUI, hit and run, reckless driving, and failure to stop at the scene of a fatal accident. During his court appearance, his attorney acknowledged that the victim had crossed against the signal, but emphasized the unfortunate circumstances.
The pedestrian was out in the roadway walking against the light. He had agreed, Mr. Washington, as he was proceeding down the street.
Prosecutors, however, argued that Washington's decision to flee and his impaired state made him a flight risk.
The pedestrian was out in the roadway walking against the light. He had agreed, Mr. Washington, as he was proceeding down the street.
The judge agreed, setting bail at $250,000 with electronic and alcohol monitoring. Washington remains in custody as he awaits his next court hearing scheduled for June. On the evening of August 13th, 2011, 22-year-old Caitlyn Markham vanished from her Fairfield, Ohio, home. She was just weeks away from graduating with a degree in graphic design and had recently gotten engaged to her longtime boyfriend, John Carter. He was the last person known to have seen her and was the one who reported her missing the following day. Her car, keys, and purse were left behind, but Caitlyn was gone without a trace. For nearly 2 years, her disappearance remained a mystery despite extensive search efforts by police, volunteers, and her community. That mystery took a heartbreaking turn in April 2013 when skeletal remains were discovered near a creek in Cedar Grove, Indiana, about 30 miles from where Caitlyn was last seen. Dental records confirmed the remains were hers. Though the cause of death could not be definitively determined, the case was ruled a homicide. Investigators continued working the case for nearly a decade, but it wasn't until March 2023 that a major development occurred. John Carter was arrested and charged with her murder. Prosecutors later revealed chilling evidence that helped build their case. Among the findings were disturbing writings from Carter, including violent phrases and references to Caitlyn. Investigators also noted that Caitlyn's wrist had signs of sharp trauma and suggested that her body had been moved after. Though Carter never confessed to how she died, prosecutors believed her death occurred during an act of physical violence. Facing overwhelming circumstantial evidence, Carter opted for a plea deal. On June 7, 2024, John Carter pleaded guilty to involuntary manslaughter, avoiding a trial on more serious murder charges. The plea acknowledged that he had caused Caitlyn's death during a misdemeanor assault, but offered no details. On July 18, 2024, Caitlyn's father, Dave Markham, delivered a moving victim impact statement. He expressed the enduring grief of losing his daughter, saying that not a single day passed without thinking of her, and he wished for John Carter to experience the pain their family had endured for 13 long years.
Your Honor, I could go on and on about how painful. Every Christmas, birthday, the date she was found for the past 13 years. The bizarre phone call I received from John screaming in my ear that Caitlyn is missing. The odd 911 call. How I watched John attend searches and visual candlelight services, knowing that he knew exactly what she was doing. Dating her best friend, having children with her, and then marrying her. Yes, the pain and anguish are real. The worst nightmare a parent ever dreams will happen to them. Your child goes missing. That happened to me and lasted nearly 2 years before she was located. And she was located in a pile of trash. The action displayed by John as she was tossed out like garbage. The lack of human respect by John is disgusting and scary. John has no respect for anyone, only looking out for himself. I hope there's no one else next. It is very heartbreaking knowing someone treated your child with such disrespect and the impact it has on your child and her sister. Allie was and is devastated. She wanted to be an aunt, but John Carter took that away from her and proceeded to live his life as if nothing had happened. Not a day goes by that I did not think of Caitlyn. She had talent, dreams, and was making a name for herself. She was a bright, bubbly young woman, and it hurts knowing I do not get to see her blossom. See all the wonderful artwork she would have produced. I am so proud of her and look forward to a wonderful life with my 2 girls. John Carter took that away from me. John has caused so much grief and pain for my family, my friends, the community, and myself. The most recent event happened just a few weeks ago. Allie walked into a Home Depot and John was there with his family. How horrific for Allie to have to see the person who murdered her big sister was there living life. John pled guilty, but was still free. Allie has that fear every time she goes in public that she may run into John.
Caitlyn's sister also shared her thoughts through a heartfelt letter read aloud in the courtroom.
Tina Baird on behalf of the Markham family, and I would like to start by reading a statement from Caitlyn's sister, Allie Markham. Judge Boyd, my name is Allie Markham, and I'm Caitlyn's little sister. I was 15 when my sister went missing. I'm now 28, older than Caitlyn ever got to be. Putting my thoughts and feelings into words has proven to be very difficult for me. I have shied away from the media and found it very difficult to open up about the pain I've experienced, even with my friends and family. As I was just entering high school when everything happened, I feel John Carter stole the last years of my childhood and most certainly changed my life forever. For almost 2 years, I had hope that Caitlyn was still alive. I wondered where she was and what she could possibly be going through. At 15 years old, I thought about the possibility of my sister being trapped in someone's basement, being tortured, and trying to escape. I had nightly dreams that she would one day come home like nothing happened, and everything would go back to normal. But as we know, that didn't happen. Instead, I watched my parents' lives be shattered. We all tried to navigate holidays, milestones, everyday life without Caitlyn. I lived with the guilt that maybe if I had been there that night, this would not have happened. John Carter and his mother actually planted seeds of doubt that it was my fault for not locking the downstairs window, possibly allowing an intruder to get at Caitlyn. Only to find out 13 years later, the intruder was him. I watched John Carter hug my dad and try to console him, knowing Caitlyn was never coming home because he had killed her. During his search for Caitlyn, John lied to me. He reassured me that everything was going to be all right. He told me he was journaling and he planned to share the journal with Caitlyn when she returned. He said they were going to laugh together about how people were treating him and accusing him of doing something to her. In that moment, John saw a teenage girl upset because her sister was missing. And he chose to manipulate her to better his own image. He knew he would never be able to share that journal with Caitlyn, if there even was a journal, because he had killed her and he had hidden her body. John took so much away from this world when he ended Caitlyn's life that night. He stole the sunshine she would bring to any situation. He stole her contagious laugh. He stole her amazing talent. Talent that Caitlyn never got to develop.
Throughout the hearing, Carter remained silent. The judge criticized him for showing no remorse and described his plea as strategic rather than heartfelt.
And when the court looks to the sentencing factors it is obligated to consider, it has to look at it through the lens of this case. To that end, as the defendant states in the sentencing memorandum, it is clear that there are serious physical harm is the most serious physical harm that the court could possibly consider, the death of the victim. The court also considers that the offender's relationship facilitated the offense, and that was never in question with respect to the relationship that existed and has been acknowledged both in the letters on behalf of the Markham family as well as the letters on behalf of Mr. Carter speak to the nature of this relationship, the loving, caring relationship that existed between these two people. And of course, we see that on all too regular a basis in courts throughout Butler County, the state of Ohio, and everywhere. The domestic violence and the types of acts that take place behind closed doors are tragic. Tragic. That they come out of these relationships that are supposed to be built on love and trust, and that's not where they end. The court agrees that Mr. Carter has no criminal history aside from the case that's before the court today. The court does take exception, however, with the assertion that when we talk about the recidivism factors, that none apply to Mr. Carter. The court believes that Mr. Carter has shown no genuine remorse for this offense. And that is exhibited through the fact that if we look at this through the lens of the charge to which he pled guilty, that essentially this was in the eyes of the law, as it would apply to that particular charge, a misdemeanor offense gone horribly wrong with an unintended consequence of the death of a loved one. What is the reaction that a human being would have? It was a shoving match, it was an assaultive behavior, it was some type of a misdemeanor offense with no resulting intended. When does the call come? Begging for help and assistance. When does the acknowledgement come? That this person that I've loved, that I've caused their death, that her family needs to know, that the community needs to know, that they don't need to be constantly in fear that there's some madman on the loose that would break into random apartments and attack anyone and everyone in the city of Fairfield. Ultimately, there was a plea, and there was some degree of responsibility that was accepted by the defendant, but it was calculated. The cost-benefit analysis that the state offers rings true with the court. The lack of any true explanation in the body of the pre-sentence investigation or otherwise, the court finds it disingenuous to believe that there can be genuine remorse without acknowledgement of what took place. Counsel, if you and Mr. Carter would please approach the podium. The court has considered the record and overriding purposes of felony sentencing to protect the public from future crime and to punish the offender and promote the effective rehabilitation of the offender, using the minimum sanctions needed to accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the seriousness and recidivism factors set forth in Ohio Revised Code sections 292911 and 292912. I have considered the information contained in the pre-sentence investigation, as well as the victim impact statements and the mitigation statements that have been offered to the court. I have also considered any and all statements that have been made at this hearing. In light of those considerations, the court imposes the following sentence. The court finds, based upon the serious nature of this offense and the factors that have previously been indicated, that anything short of the maximum sentence would demean the seriousness of the offender's conduct and its impact upon the victim, and therefore will impose a definite term of incarceration of 36 months. There are 14 days of jail time credit to which the defendant is entitled. Being that the court has imposed this sentence, there is also a mandatory period of post-release control of a minimum of 1, not to exceed a maximum of 3 years. If you violate the terms and conditions of post-release control, the parole authority can return you to prison up to 9 months per violation, up to 1/2 of the original sentence. Also, if you commit another felony offense while on post-release control, the sentencing court could sentence you to prison for an additional year or the time remaining on post-release control, whichever is greater, just for committing the new felony offense. That time would not be included in any sentence on the new felony conviction itself. Do you understand that, Mr. Carter?
Yes, Your Honor.
The court has considered your financial resources and your ability to pay financial sanctions both now and in the future. The court will order that you pay court costs. If you fail to pay the costs associated with this case, the possibility exists that you will be ordered to perform community service work and given credit towards the outstanding balance for each hour of community service performed in an amount equal to the then existing amount of minimum wage in the state of Ohio. I note for the record that there was no restitution that was requested in this case, as the court was made aware that funeral expenses were taken care of by a third party. Mr. Carter, you have the right to appeal the sentence in this case. You do that by filing a notice of appeal with the clerk of court for Butler County within 30 days. If you're unable to pay the costs of the appeal, you have a right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, counsel will be appointed without costs. If you're unable to pay the costs for the documents necessary for the appeal, those documents will be provided without costs. If you wish to have a notice of appeal filed on your behalf, you simply need to instruct your current trial counsel to file that, and then ultimately, if it's retained counsel, they'll handle that issue, and if you need counsel appointed, they'll have you fill out an affidavit so that the court can appoint counsel if that becomes appropriate and necessary. Counsel, anything else that you wish to place on record?
No, Your Honor, thank you.
Mr. Carter is ordered remanded to the Butler County Jail pending his transfer to ODRC.
Carter was sentenced to the maximum 3 years in prison with credit for 14 days already served. The sentencing brought some accountability, but not peace. Caitlyn's family expressed their frustration with the limited sentence and the lack of answers. They now hope to advocate for legislation, dubbed Caitlyn's Law, to strengthen penalties in cases where victims' bodies are hidden to avoid harsher charges. In the summer of 2024, the peaceful community of Plain Township, Ohio, was shaken by the sudden disappearance of 24-year-old Rachel Sheridan. On July 2nd, after she failed to show up for work, her concerned mother requested a welfare check at her apartment. Deputies arrived and found the door ajar, with enough concerning details to launch an immediate investigation. Not long after, they spotted Rachel's Jeep nearby and pulled it over, only for her boyfriend, 27-year-old Sean Go, to flee on foot. He was found the next morning at a local shelter and arrested on several outstanding warrants, including burglary, theft of a firearm, and domestic violence, a prior case in which Rachel had been the victim. Tragically, on July 3rd, a sanitation crew discovered Rachel's body at Mother Goose Land Park in Canton. Wrapped and placed in an attempt to conceal what had happened, the discovery launched a deeper investigation. Authorities soon gathered forensic evidence tying Sean Go to the crime. Investigators recovered a weapon suspected of being used in the incident, as well as gloves and a bucket containing DNA from both Go and Sheridan. The details that emerged painted a picture of deliberate harm and attempted cover-up. Prosecutors later revealed that bleach and other cleaning agents had been used at the scene to obscure evidence. As the case moved to trial in the fall, more disturbing information surfaced. Go's criminal history included past convictions for burglary, theft, and drug-related offenses.
I've also taken into consideration Mr. Go's previous record of a violent crime. On January 11, 2017, he was convicted of burglary, receiving stolen property, and possession of heroin. He was sentenced to 4 years in prison. Falsification, carrying a concealed weapon, and criminal trespass on July 14, 2006, where he served 15 days in jail. Theft on March 2, 2016, where he served 10 days in jail and 2 years probation. More importantly, at the time of this incident, this murder, the defendant committed these offenses. There were 5 warrants for his arrest out of the Canton Municipal Court. 3 of the warrants were for burglary, felony of the 2nd degree, theft of a firearm, felony of the 3rd degree, and criminal damaging filed on June 17, 2024. Additionally, there were 2 more warrants for domestic violence, misdemeanor 3, and criminal damaging M2 for a case that occurred on May 3rd, 2024. And it's important to note that in the latter case, Rachel Sheridan was the victim.
At the time of Rachel's death, he had 5 active warrants, 2 of which related directly to her. On November 8, 2024, a jury found Sean Go guilty of murder, felonious assault, tampering with evidence, and gross abuse of a corpse.
All right. Mr. Go, last Friday on November 8, 2024, you were convicted of 2 counts of murder, felonious assault, tampering with evidence, and gross abuse of a corpse. The 2 counts of murder and felonious assault each carry what are called repeat violator offenses, which were tried to meet the court, which then the court found you guilty on those 3 charges based on the evidence.
The sentencing took place on November 18, 2024. In a solemn courtroom, Rachel's family delivered powerful impact statements. Her aunt, brother, and mother spoke of the immense loss they now lived with daily.
I'm Aunt Sue. I've known Rachel her whole life. From the precious moments we found out Lisa was pregnant. The pain Sean has caused us, or me, not to mention her mom, Dwayne, Jonathan, and many, many more, is unforgivable. I would ask you, Your Honor, to impose the maximum sentence with no possibility of parole. I'd be crushed if he got out and did this again to somebody else's little girl. Thank you.
Thank you. Thank you for coming.
Jonathan.
You want to just state your name for the record, please?
Jonathan Gilliland.
Please proceed.
So, there's no amount of tears, shouting, drinking, smoking, or whatever vice that can be thought of that will be able to repay Sean in kind for what he's taken from us. Myself, my mother, Dwayne, her friends, and many others who knew Rachel not by her personage, but from her story and held sympathy. No amount of tears, shouting, pleading, good behavior, or the likes should be able to give Sean back to his family, or at least soon. However, on the bright side, at least his family will have the ability to see their loved one, to talk to interact with him once in a blue moon. At least his family will have the option to remain happy in life because he's still alive and well and not dumped in a garbage can. The fact that he gets to be alive and well despite what he's done, and the fact that his family gets to talk and see and interact, in my opinion, would be unfair and unjust. Because far more people than he knows no longer has the option for that for Rachel. He stated many times that he loved her. If he loved her, he wouldn't have hurt her the many times that he did in the past. He wouldn't have decided to take his own anger out on her for any reason, big or small. He wouldn't have done the many things that he did if it was love that he felt for her. He felt no love despite how much his heart or brain told him that he felt. He felt control and despair whenever she didn't listen or argued with him. He said he feels guilt and anguish for the very things that he's done because he knows it's wrong, yet he did it anyways, despite that love that he claims he felt. Now and forevermore, he has to live and deal with that guilt, experience it. When each and every day spent in prison be filled with some sort of reminder, because outside, where her friends and family are, the ones who truly love her, I should say, outside where we are, we will be reminded daily. In the sun, the flowers, the Jeeps that looked like hers, and the countless of other domestic violence cases that do not get resolved quick enough.
Okay, thank you. Is there a third speaker?
Yes, Your Honor.
Take your time.
I'm sorry.
Take your time. No rush, you take your time. Can you just state your name for the record?
Lisa Sheridan.
Please proceed.
My fiance and I would like to give our statement.
Absolutely.
Sean, to begin, I would just like to say that you have hurt us more than anyone else could have. You have taken one of the greatest joys in our lives. She was a true sunflower in our darkest days. You have our baby girl. My question is, why would you do this to someone that loved you, who wanted to help you through your own personal battles? She stood by you regardless of what you did to her.
Her mother described Rachel as a sunflower in their darkest days and asked why someone she loved and supported would ever choose to harm her. Sean Go's adoptive mother also addressed the court, acknowledging the pain her son had caused.
I cannot understand
begin to understand the pain and grief that you are enduring, and there are no words that can ease the hurt or bring back what has been taken from you. No matter the circumstances, no one should have to experience the kind of loss that you are facing, and my family and I are deeply sorry for the pain that my son's actions have caused. We love Rachel. She was a part of our holidays and weekly Sunday dinners for the last 3 years, and the absence of her at our table was heartbreaking, and she will forever be missed by us. I recognize the devastation that his choices have brought into your lives, and I will carry the weight of that sadness with me always. I can only hope that in time you can find some measure of peace and healing. My thoughts are with you, and again, I am deeply sorry for your loss. I would also like to share some important context about my son's early years, which I believe are critical in understanding the person he is today. Before he came into our family, my son endured an incredibly difficult and traumatic childhood. He spent time in multiple foster homes, far more than any child should have to endure in such a short period. The instability, the uncertainty, and the emotional toil of being moved around so frequently had a profound impact on him. In addition to the upheaval of those constant moves, he also faced abuse and neglect in some of those homes, experiences no child should have to go through. These early years left deep scars on his spirit, and though we tried to provide him with a loving, stable environment after his adoption, the trauma he experienced before coming to us was something that would take years to heal. His birth parents struggled with addiction and mental health issues, and the pain of those experiences only compounded what he had already been through. It's no excuse for the choices he's made later in life, but it is an explanation for the pain and confusion he carried with him. That took a hold of him were a way of coping with the deep inner turmoil, and they led him down a path that has caused harm to himself and others. Despite all of this, my son has always had a kind heart. He was always the one to help others, especially the elder and children, and he always tried to be the person who made those around him feel valued and cared for. I believe in him. He is not defined by the mistakes he has made. He is someone who has faced unimaginable hardships and is still capable of healing and turning his life around. I ask the court for mercy and to recognize that my son is a person who is shaped by a history of trauma, but who also has potential to change. He deserves a chance to rebuild his life, and with the right support, I know he can become the person he was meant to be. Thank you.
She asked for mercy, believing her son still had the potential to change. But the court, though respectful of her grief, remained firm. Judge H. Frank Forchione called the case the most senseless and brutal he had seen in his 17 years on the bench.
But I've been on this bench 17 years, and I agree with Mr. Barr. This is without a doubt the most brutal that I've seen. It was difficult up here even listening. It's appalling. It's heartbreaking. Rachel Sheridan was beaten so severely that the sheriff deputy who saw her body couldn't identify her based on her own photo. A hammer, or some type of instrument, was used that crushed a 3-by-2-inch hole in her skull, her upper jaw being broken into 2 places and pushed into her face. Her lower jaw was also fractured. The force so devastating it collapsed her cranial cavity into her brain tissue. The coroner described a portion of her face virtually exposed. There was testimony from both the coroner and detective that this type of damage could not have been done by a fist, but required a serious violent impact, which they estimated at least 10 different injuries by blows. The coroner noted the cause of death was multiple blunt force injuries to the head. Then, in an attempt to cover up your cruel and cowardly actions, you then tampered with the evidence, using some form of bleach and other cleaning devices in an attempt to cover up your guilty trail. Your deceitful conduct was further exhibited when you were stopped by a police officer on videotape due to the fact that there may have been a warrant for you, but only, and I mean only, after you advised that Rachel's whereabouts were unknown. Instead of being worried or concerned, you ran. Your devious plan didn't stop there. Later at the Refugee of Hope, you attempted to secure a free bus ticket to leave town to cover up this dastardly scheme. The senselessness of this murder tells me not only are you morally bankrupt, but you have no fiber of decency. Displaying the lowest level for human life, you then wrapped the body in a sheet and dumped it in a park near Mother Goose Land. This is the person at one point you claimed that you were in love with. Instead, you threw her in the trash like a piece of garbage. The only thing that stopped you getting away from this crime, you almost pulled it off, was excellent work by the Canton Police Department, Stark County Sheriffs, and your own one fatal flaw, keeping Rachel's phone in your possession. I'm tired of people trying to blame everyone else for their problems in life. Everybody's had a difficult life in one way or another, so I don't find that your childhood excludes anything. We seem to live in an entitlement world for some reason. But I want to make sure you understand something, son. It is my job to protect this community, and I will do so. I will do everything I can to lock you up for a long, long time. It's obvious to me that I cannot rehabilitate somebody like you with such a disregard for human life. I will now announce the sentence. On count 1 murder, an unclassified felony, I sentence you to a definite sentence of 15 years to life. As I indicated, count 2 murder and count 3 felonious assault merge. As to the repeat violator offender, that's a little bit different. That's up to the court, and you can order a sentence of 1 to 10 years. I am ordering you to serve the period of 10 years consecutive, and that would be served prior to any other sentence that you will be serving. Tampering with evidence, you will serve a definite sentence of 36 months. Gross abuse of a corpse, you will serve a definite sentence of 12 months. So since this is complicated, I'm going to walk everybody through this so you understand. You'll serve 15 years to life on the murder charge. You will serve a mandatory 10 years on the repeat violator offender specification, which is consecutive. And that'll be served prior to the murder sentence. 36 months definite sentence on the tampering evidence and the 12-month definite sentence of gross abuse of a corpse. Both of them will be consecutive to the murder and repeat violator sentences. So in a nutshell, that's 29 years to life. Mr. Go, you sold your soul to the devil. I've ordered you to receive the maximum sentence on every count due to the fact that you deserve the maximum sentence. The reason the maximum consecutive sentences are being imposed because you committed the worst form of the offense. And there's a great likelihood you will commit a future crime.
He described Go's actions as morally indefensible and stated that the severity of the crime, coupled with Go's criminal history, left no room for leniency. The judge sentenced Sean Go to a total of 29 years to life in prison, 15 years to life for murder, 10 additional years due to his status as a repeat violent offender, plus 3 years for tampering with evidence and 1 year for gross abuse of a corpse, all to be served consecutively. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.